afternoon, our dear viewers, and welcome to this edition of the Inter-University Debates. As the city braves the hot weather, we sit here to discuss several hot issues that have been pertinent in our political dispensation and current affairs over the last 1 month, as we have all been following. Of course, the Inter-University Debate brings together some of the brains of clarity from the different universities to be able to participate in this discourse and also guide thoughts of their fellow youth, but also the citizenry at large. Today, we shall be riding across several issues. First, and of course, in particular, the issue around the reenactment of sections of the UPDF Act, a proposition moving forward, starting with the NRM caucus, that despite the Supreme Court ruling on the 31st January 2025, outlawing the trial of civilians in particular courts, the NRM caucus moved to discern particular instances where trial of civilians may proceed. Of course, that comes in a heated political environment where we have a country discussing the political case, political and legal case, or as we call it, lawfare, of Kizza Besigye, issues around contempt of court, a time where the Uganda Law Society president is a convict, has been convicted and sentenced, but also he has a new arrest warrant on the matter regarding his language towards the DPP, among other political issues. Of course, we also noted the NUP parade that attracted a military raid on some of their premises. So we have a wealth and a breadth of issues to discuss. And of course, to delve in with me today, we have Mr. Luwaga John Eliane, a UCU law student. You're most welcome.
Thank you. And I'm grateful to be part of this panel to discuss the matters that we're going to have today.
Thank you, and you're most welcome.
Thank you.
Yes. And of course, on my right, the very able Miss? I was checking if you're alert. Miss Acayo Monica, a lawyer. You're most welcome.
Thank you so much. It's an honor and pleasure to be on today's panel. Yes. And I'm very excited and looking forward to the conversation at hand.
All right, thank you very much. Of course, there's a lot of law on the panel, so for purposes of today, I'll dispose my legal hat and wear a political hat to balance the debate for our dear viewers. Anyway, going straight into the discussion, I'll start with you, Comrade John. We saw last month the Supreme Court, of course, coming out to, rule that trial of civilians in court-martial or in military courts is outlawed, and all cases should be transferred to civilian courts. First of all, what do you make of that judgment?
Well, thank you for that topic and that question. When you look at that decision came at a time when the famous Dr. Kizza Besigye was being tried, and I think the legal officers that were in charge of his case were trying to buy time to see to it that that decision comes at that same time when he's actually there, so that they give that judgment to the court-martial, so that actually he's released. That was their thought at that time. So when that decision came, we actually, as Ugandans, were happy to have that decision because it was in a time of politics. We are in 2025, going in for elections, and we are having this conversation because the ruling regime has that intention of always taking civilians to court-martials, and then after trying them and then leaving them there, because we still have instances of those ones who have never been out. From 2021, we have those who have never been out. So we always want that judgment that would actually be the end to that actually brutal decisions. So when it came out, we really were happy. I was personally happy because the decision really entailed the rule of law. It entailed judicial independency. It entailed will by the people. It looked at Article 1 that power belongs to the people. It was a clear indication that whereas the executive might be interested in trying civilians in a court-martial, the law says otherwise. they actually dissected properly the UPDF Act and saw that indeed there are some sections that should be declared null and void and make recommendations where need be. And in that particular instance, it talked about the fact that the court-martial should only be restricted as a disciplinary committee, not even as a court, not even as a tribunal as such, but just a disciplinary committee. And it even ruled that in instances where even an army officer has committed an offense tried by the other courts like the High Court or the magistrate courts, there is no reason why we should have a parallel court that will try the same issue. Until that point where the court-martial is trying to deliberate on that matter, that's when whatever they are doing is supposed to be null and void. And that was the decision of the what? Of the Supreme Court. It went ahead to even give recommendations that among them they should look through the UPDF Act and try to make provisions to the effect that the civilians should not be tried in that court-martial. And in that particular instance, I want to say that the president shut it out on the very next day, just few hours before 24 hours actually elapsed. The president had already made a recommendation, had made a decision on the same decision. So at the end of the day, we see the conflict between the organs.
But then,
yes.
Just to chip in there, of course, the president had his opinions and reservations regarding the, removal of those powers from the court-martial, citing historical reasons, and the president can tend to be a hardliner and stubborn with his ideas. But to his credit, there's been a transfer of cases, including Dr. Kizza Besigye, who even lifted his hunger strike on the note that, well, I'm now in the civilian court. Aaron Kizza, though it's being haggled, but it's in the civilian court, among others. Don't you give credit to the president and the executive for that progressive take, to align with the Supreme Court ruling?
Well, in instance, I will not give credit to them. Why? The issue is simple. They will try to blindfold us that they are trying to actually do whatever they are doing, that they are trying to respect the decision of the Supreme Court. You're going to realize that whatever they're going to enact is actually going to be a total mess from what they said. It will beat my whole appreciation to what they are doing. Now, if you look at what they are, for example, doing by transferring cases, they have not yet transferred the specific case that Besigye was facing in the court-martial. That one has not yet been heard. Whatever Besigye is facing in the High Court and the rest of the courts were those particular cases he was actually having. He had particular cases way before.
The issue of weapons.
Yeah.
Yes.
So whatever was
the going argument is that was a holding charge.
So whatever
the holding charge that metamorphosed into the current charge of
they were
treason.
blaming him of carrying weapons.
In other words, carrying weapons can be treason.
Well, that is perhaps in the eyes of someone who might not have understood
in the eyes of the PCA, possession of weapons is treason.
Well, I would understand that in the eyes of them, it is treason, and which is okay. But now the issue is they're trying him of treachery, they're trying him of possession of armed weapons, and now they have metamorphosed it into the cases that they're having before. Now, they're going to see that the cases they're going to enact, because for me, I'm looking at the whole UPDF Act they're going to bring. That is why it would show that they're actually not having an interest in basically not being tried by the court-martial, because they want to bring all those things back into the whole thing. So I would not appreciate them, because I know they're going to do the same thing to enact a law that really would bring civilians back. I don't know which civilians want to be tried in that court-martial, because for them they're insisting that civilians want to be tried. I've not seen any civilian who is interested in being tried in the court-martial. So at that point, I would not give them credit for doing that. It's like me thanking them for the air I'm breathing. That is supposed to be the rule of law. That is supposed to be the issue at hand, because the decisions by the Supreme Court were that there is no fair hearing in a court-martial. Now, I do not know which people they want to take back to that same court-martial. That at the end of the day, the principle of alteram patam would be dismayed. It would be disbanded, because that's Article 28, which is the heart of the Chapter 4 of the Constitution. So by us appreciating them for what they have done, that is what they should have done in the first place. By you slapping me, and then I blame you for slapping me, and then you apologize, I shouldn't thank you for apologizing.
All right, thank you very much. I'll bring the argument to Monica. Monica, I think there is some need for discernment, because Well, right now we had a caucus, NRM caucus. If I'm not mistaken, it was Monday this week that came out with three key points. One, that military personnel should be tried in the court martial, including cases which are not necessarily in the direct course of war. So if a soldier raped somebody, etc., disciplinarily, they should be taken to the court martial. That's one. Two, that civilians should be tried in the court martial if they're in possession of illegal weapons. And then three, introduction of an appellate system for the court martial, that whatever convictions come out of the court martial for soldiers or civilians with illegal weapons can always be appealed to the civilian courts. So what do you make of this? Do you think it's a total reversal, like he's saying, or it's a reversal that will capture Besigye but will release Aaron Kiza, who was, for example, just, imprisoned for contempt of court? Help our viewers to discern.
Okay, thank you so much for the opportunity to chip in. I think, first of all, to form an opinion that is not clouded, you must be able to appreciate the country and the three organs and how they are supposed to operate, right? Now, when it comes to the three angles that the NRM caucus came up with, you'll understand that technically the court martial exists because of certain things, right? Now, the reason as to I agree with the points, and I'm going to explain why I agree with the points. One, a civilian who is in possession of illegal weapons, that alone or in itself it poses a threat to the general public. Why? We have laws in Uganda that allow a civilian to acquire weapons legally. You can have a gun registered in your name. There are procedures to it. So if you are found in possession of such weapons without...
You cease to be a civilian?
No, you do not cease to be a civilian, but then your intentions...
I mean, if you're found with a bazooka, are you still a civilian?
Well, the point is, if they bring your character into question, you shouldn't be defensive. Because we've told you, you can have it this way. Why are you using the other way? Either you're smuggling it in, or you have other intentions. Because now the reason why, if someone is found with a weapon that is not licensed, we can't trace it back. You can use it to do whatever you want to do, kill people, or even cause these unrests. And it is no secret that Uganda has been prey to various people are being shot down every day. People are being, things are happening. So if we cannot trace this back to the ammunitions used, then at the end of the day, you're going to again blame the same government, saying they're not protecting the country, they're not doing what they're supposed to be doing. Additionally, now that civilian who is in possession illegally, technically those are matters that are beyond commercial court, beyond civil court, beyond criminal court, because there are certain parts of the law that need to be burrowed down into, and only experts can do that. And those experts can be found in the court martials. So it makes sense to send them there. That is one. Two, the court martial. Okay, when you join the military, I happen to have a few persons that I know in the military. When you join the military, the level of discipline or the bar that is placed onto you as a person who has joined the military is high. And whether you've joined as a doctor or you've joined as a worker, cleaner, or even as a military personnel, it differs. So that means that the level of discipline they're going to expect from you differs from the one they would expect from a civilian, right? It's like medical negligence. A doctor that has been trained and is licensed to practice cannot be treated the same way a midwife will be treated if they created or caused the same problem. So them being sent to the court martial, irrespective of the nature of crime committed, I personally don't disagree with it. It's a position that works because you ought to know better because of your exposure, because of the line of work. So in relation again to the Supreme Court decision, the Besigye case, which is now everywhere, and of course with respect to all the organs, in law we have something called winning on paper, but when on ground there is nothing really working for you. So what we have is a win on paper, but the execution of that win may be something that will never be materialized if it is not scrutinized properly. So back to his point, we may actually have judgment that says A, B, C, and D, and the whole country goes and celebrates and is happy about it. But at the end of the day, if we do not follow up the execution of these judgments, it will always remain just a judgment, and nothing will materialize. So I think what NRM is trying to do is find a reconciliation between the position of the law, what the people want, and the current state of affairs in the country. Because everything is really political.
All right, thank you very much. I think one thing, of course, there are very strong debates that military matters, civilians with weapons and others, terrorists, etc., can be tried in civilian courts, citing, of course, cases like the Al-Shabaab, which was, by the way, handled by the current FBI director, the US. So there are strong arguments for that, and I believe there will always be a point of departure. We may have to just disagree to agree on that. Otherwise, yes. But now, moving on with the discussion in terms of the whole issue of the legitimacy of the courts system that we have. I think, don't you think the recent developments have played to redeem the courts of that question of independence? When we look at the Supreme Court ruling, our court system is flawed. Monica, this is to you. Our court system is flawed, but still, wasn't that a winning point on independence of judiciary? Of course, coming from a long history of Udo Udoma, ex parte Matovu, and so many cases where political question doctrine has haunted this country, as our preamble says. Don't you think that was a score for the judiciary?
Yeah, I agree. Political question doctrine has always been a thing in this country because we have what we call pseudo checks and balances, pseudo independence. But the fact that the judiciary itself went and said what it said, well knowing the position of the executive, and remember the position of the executive usually doesn't differ so much from the position of parliament, but the judiciary, which is supposed to breathe life into the laws, went ahead and breathed life into, like he said, Article 1 of the Constitution. It's a pointer. It's a 1 point for them.
All right. And then before I go back to our colleague, do you think there are enough safety nets? Because the effect of the reversal of course, the effect of the amendment being pushed by NRM is that Besigye goes back to court-martial because he was one of, it's treachery, but therein is the charge or evidence of possession of illegal weapons. Do you think with the current environment, the court-martial would be trusted by the citizenry to deliver, a sound judgment or fair judgment?
Thanks. That's a tough one, but I believe the reconciliation therein would be choice of the people sitting on the court-martial. Remember, the tribunal, or what we would now call the judges, the person being, if Besigye is sent back there, they should at least to give room for fairness, fair hearing and all that, they should give him an allowance of at least dictating or agreeing to who makes the bench. That way he can be
But it's a disciplinary committee, so...
That's the whole point. Because, you see, there's not going to be one particular happy party and then the unhappy party.
Yes.
There has to be a meeting of minds somewhere. Because we're saying go back to the court-martial, okay, fine. Because the nature of crimes they are assuming he committed belong to that court. It has the jurisdiction therein, right? But his fear is, I'm going to go there, but you guys are already impartial. You're already partial, and you're not going to give me audience. And even if I present the best case and the best pieces of evidence, you have already made up your mind. So at least My point is, they have to come up with a neutral way of picking who sits on the panel to make the decision.
All right.
At the end.
Thank you very much. My brother, John, can civilians, sorry, not civilians, but can non-lawyers, like, of course, the bench leader, in quotes, leader, Mr. Freeman, be able to provide adequate judicial dispensation in the court martial in cases like Kizza Besigye? Or do you think, as she says, it's only lawyers? After all, there is appeal. We also have LC1 courts. They don't have, in fact, LC1 courts dispense the most justice in Uganda. They don't have lawyers, and they settle issues.
Mm-hmm. You see, in a courtroom where the cat is the judge, the rat will never receive justice. That one is very clear. Even when the blind is brought to see these facts before us, the blind will see that indeed there is no justice where the person now in question, now, who is now a military official, is the one trying this civilian, is the one trying this individual, yet their knowledge in the law is questioned. Now, the issue is...
But they have military knowledge.
Yes, let's first understand this clearly. The court-martial, the people who introduced it at the beginning, from the onset, were looking at it as a disciplinary committee. Way back in campus, way back in high schools, way back in secondary schools, we had disciplinary committees.
Without lawyers.
We did need lawyers for those ones. That is the issue. That is how that court should look like. It should just have people for issues, petty issues actually. And that is what they were stressing in the 200-page decision by the Supreme Court. That if you really want to try an offense, a particular offense covered by the penal code, then allow us, we as the judges, to give you a hand in appointing the people you want to be there. Because you don't appoint someone who has no knowledge about adulterarium pattern as a law, as a principle of criminal law, that you're going to give them submission to actually listen to lawyers and make a judgment. I can't submit before someone who doesn't understand what I'm submitting. Someone who is actually someone who should be lower than me in my understanding of the law. Now, we are looking at what we call the Dunning-Kruger effect. That the people who honestly know nothing about a particular issue will overestimate their competency in understanding it. And those ones who actually know a lot about it will underestimate their value and their knowledge and competence on that particular issue. We are looking at the President Museveni and his team thinking they know a lot about the law. They didn't study. They want to educate us about the law. They never went to school to study. And they want to tell us that for them they will give justice on a matter that involves civilians carrying guns. Let's take an instance way back. Let's draw our minds way back to 2021 to date. How many people have been captured? We have captured Dr. Besigye. We have captured the NOP supporters. We have captured Kyagulanyi. And we have taken them before those courts and said allegedly that they have been possessing guns. We have never brought that evidence before those courts. But till date, they have been suffering and, they have been incarcerated. But that's the point that the Supreme Court was noting. That at the end of the day, we have what we call the Chesterton effect. That you will not try to break down a bridge you did not bring. You did not put forward. You did not have a clue why it was put. If the Supreme Court has said, please, end here, stop here, don't continue, you want to break that and make a way. At the end of the day, you will find that at the end of the day, there is, let me say, no way out. And for you just broke that bridge, you broke that fence to make a way. At some point, you have to ask yourself why they made that decision like that. They really gave a very good judgment on more than 200 pages for someone to read, for someone to understand. If it was English, it was very clear that they tried to be like as if they're educating primary school children. That, look, there is no justice in that court-martial if the people who are trying are people who do not have any knowledge in the law, are people who actually have to submit to the appointing of the authority. That is why, because when you look at the court-martial, it is part of the executive. It's not part of the judiciary to begin with. The executive is the one that has that court-martial as a disciplinary committee. Then why would it try someone as though it is a judiciary, a court of law? It should not be like that.
But
an arm of government is supposed to be independent to make the law. An arm of government is supposed to be independent to interpret the law. an arm of government is supposed to be independent to execute that law. For you to come out and say you're executing while implementing, while making, while interpreting, you're making a blunder. And that's what we are saying.
Yeah, but the state has valid points. Besides 2021 to now, including the resolution of the Karamoja guns question, which I come from actually, was a big issue. To know that there were tens of thousands of guns next door, flipped in through porous border points that were handled by the court martial. Now, therein, some qualities were cited. One including speed and the absence of legalese, legal curtains of bureaucracy that would delay certain processes and bringing justice in a way that related to the people of Karamoja. Now, is that a question of improvement on the side of the civilian courts, or it is an actual merit of the military court?
All right, let's go back to
because the issues with 60% of people in our prisons are on remand, some even 6-10 years. So how do we reconcile those flaws with urgent issues of security?
If I'm to look through the president's issue and his outcries to the country about the military courts trying civilians, I understand in paragraph 9 and 10, he cited the issue of Karamoja in his letter that he sent. He cited the issue of Karamoja and how it was a speedy trial. But let's first look at the fact that what is the principle that we are looking out for here? The principle of legality. The principle of legality entails in Article 28, 7 and 12, that at the end of the day, you will not try someone for an offense that is not clearly understood or defined, isn't that? Nulla poena sine lege. That at the end of the day, what amounts to an illegal weapon? Will you be able to define to us what amounts to an illegal weapon? Let me take a point. Let me say I find a gateman with a pistol or with a gun and is trying to protect the citizens, like to keep the people in check. And then I steal that weapon and gun and I take it. Will that be the issue they are looking at, that weapon that I've stolen? Because at the end of the day, we don't have weapons. We have those weapons that would have UPDF. We have those which have nothing. So what amounts to me having an illegal weapon? How about if I went and robbed someone's home with a gun? Those are cases that the civilian courts have been trying as burglary. As you stealing, you break into someone's home with an intention to steal.
But the civilian courts would not have solved the Karamoja question.
The issue of the Karamoja question is a lack in its own disguise. They had just luck that they solved that issue away from the normal court system.
You see, okay, the debate there is that, I mean, we have, if you take time to tour the country, you'll know that the legal system is, as it was introduced in 1902 with the Order in Council, is still largely an elite. It was introduced to serve the state and the progressive elite, so-called, if you read Nativity, so-called urban elite, and maybe a few settlers here and there. Up to now, I did a tour around the country. I noticed that out of 41 districts, over 100 still don't have one lawyer. One lawyer. All of us, 80% are in Kampala and the surrounding, and then a few in, you'll be surprised by how departed we are. So the argument there is that, and it's a doctrine that NRM has carried through, with the revolutionary council courts and local council courts, civilian court martial, that while legalese is fine, but it's refined in the West. It's not where we are currently. We still need court martial to handle issues like Karamoja, where clearly they were shooting people and rustling tens of thousands of cows from their neighbors. Yes.
You see, the president has always, from time to time, put up committees to, let me say, fight corruption, to make investigations on human rights violations, to make investigations on particular matters. But at the end of the day, those committees and tribunals don't become an end in themselves. They don't become established courts of law. The Constitution has established courts of law. Those ones are fine on themselves. Now, for example, if the president put up a committee to make resources and make varied let me say, checks and balances on what the issue of land is. Like, why are there land evasions? And let me say, why is there increased corruption? And they make searches on that, and they fall on 2 individuals who are actually culpable. That these are individuals who are interested in the land division, and we have gotten them. The issue is simply because you've been successful in doing that, in making sure that the issue of land division is tackled, that doesn't mean that that becomes an established court of law. That means it has to stop there. It has done its work.
Yes.
And then you now go back to the ordinary court system.
Thank you
You've
very
just
much.
helped that issue.
You bring a
Yes.
very interesting point that some of these actions need to be case specific. Now, I want to take you a bit to the discussion on social media. I'm personally not very active, but there's a big movement saying free Besigye, and I'll get to you on the same. There's a big movement saying free Besigye. But the question there is, free Besigye, then what? Like, does it make sense from a legal perspective? Because it seems there's a loophole. I mean, is it on procedure, or is it on substance that people are crying out, or is it political, which I suspect it is, that we should free Besigye? What do you make of? Because as a lawyer, you know, there's a process. And Besigye himself lifted his hunger strike when he was transferred to Civilian Court. So maybe he wants to defend himself and his freedom.
Well, the issue of free Besigye, I would attack it from the point of view that I would not, personally, not having knowledge about what exactly is, Besigye, I do not know whether he actually did it or not. Justice must be justice. If he really is supposed to be liable for what he did, there is an established procedure in criminal law for what has to be done. Let's now look at the procedure. Like, Besigye is supposed to face his trial. Even when he is actually guilty, trial must be given. Even when he is not guilty, trial must be given. So the people who might be coming out might be politically sensitive that the person before them is actually suffering. That is their issue. But the issue is, as a law student, Besigye must face trial. Clear trial, and he's not avoiding trial. For all the days he has been facing trial, he has never escaped from this country. For trial, he has actually remained there as a stronghold for being tried. We actually just sacrificed him there for him to be tried for anything they want. He has never escaped. So the issue is, the procedure to be followed is established by the law. Let's go back and how he was arrested. He was arrested from Kenya. There is no law allowing those officials who captured him to arrest him from Kenya without an arrest warrant, without them taking him to the magistrate court or any particular court in Kenya where the jurisdiction is territorially, for him to be captured to then be sent to a Ugandan court. They just captured him in a van and brought him here. Now, the issue is, there is the law on extradition that must be followed in capturing an individual from someone else's territory outside. But that was also not followed.
But foundationally, just to guide the listeners, does that, overhaul the substantive procedure?
No, it doesn't not do away with the substantive
It's just a
procedure.
mitigant later in judgment.
It is supposed to be looked at.
Yes.
It is just the procedure we have in the law. So whether they have followed it, we can say they have not followed it. We now close our eye. But now we are seeing very many procedures being broken and not being followed. And that's why very many of those who might understand the law might come out and make an outcry about the same. So at the end of the day, nothing like extradition was done. And even in Kenya, the Kenyans in their parliament were debating on the same issue. That how can you enter our country and see someone with a gun, put it in a pocket, and then be like, this person has a gun belonging to a Ugandan UPDF official, and then you capture the same individual and take them. We have the law on extradition that says you should not capture someone who is for a political offense. Where the offense is of a political nature, do not extradite that individual. Now we're looking at whatever is happening between Besigye and the NRM. The president is always issuing messages, and it's as if he's texting on WhatsApp. Every time he's updating us about Museveni case. Every time he's updating us about Museveni case in various letters he's not even signing. Because he's in a rush. He shows the public that he's politically interested. And in the same case of Rick Asioni, they decided that where the matter is politically motivated, don't extradite that individual. In the first place, Besigye was not supposed to come to Uganda, even if they wanted, even if they had evidence that he had a gun. But because the person trying him is politically interested in him, there was not supposed to be an issue. The audios moving around show that Besigye was actually trying to overthrow the government. That is the best evidence to show that politically Museveni was not supposed to follow up on the issue of Besigye coming back to Uganda. Because he was in the process of removing a government, if that's what they say. He was interested in removing the government, meaning the issue was, the offense was of a political nature. He was not supposed to be brought back. That was done away with. They brought him to the court martial. We are saying can't he now go to the original courts of law that have established laws and procedures that will actually look at the matter? We are looking at the people who are trying him, know nothing about a legal maxim. Ask them one question about law, they will actually look at us. The procedure is what is making the problem. We have no problem if Besigye is actually guilty of an offense or not. The law is like that. It works as an axe. It just falls and breaks anything it finds. That is the law. It works like an axe. And that's why when you look at the statue of Lady Justice, there is a statue that is always having the weights. It is always blind. It's a woman that is blind. It shows that justice will apply regardless of whom it is. So it doesn't mean that Besigye is supposed to be freed or even forgiven, as those officials who are talking about, even the religious leaders that forgive. Forgiveness might not work for that particular matter. But the issue is, Besigye has to face trial, but in the established courts of law. Today, we have what we can call the poem of not my business. Very many individuals might look at this whole thing and say, it's not my business. Until now, they come for them. That is now when they will know. I know these NRM people that are parading themselves before the president are going there for lunch, perhaps to have a meal, to have a good ride to State House, to talk to the president, because they need to come back in the same election to get an NRM card. They will accept that actually civilians should go back to what? For trial in the court martial. They are looking at the poem of not my business. In this poem, not my business, the individual is saying, even if they capture people, I don't care. They are using the issue of a car, that they have captured a Kindi, they have captured this one, but it's not my business until that some person was captured at the end of the poem. That is now when the issue came to be an issue, and it speaks about people who don't want to care. Now the NRM officials will come and implement this law. They'll come and support it 100%, forgetting Article 92 of the Constitution, which says that do not, as a parliament, sit to legislate to make a law that actually does away with the position of the Supreme Court. I don't know why they're absent about this, simply because none of those officials are literate about the law.
All right, thank you very much. And of course, you recall in law school, the Grace Sibingiras suffering from the
the Grace Sibingiras.
But I want to get a final say from you. Are the people yelling free Besigye misguided?
They're misguided.
Okay, thank you.
They're very misguided.
Your take on that before we go on to a break.
Thank you so much. Free Besigye is misguided. I think it's backed by, of course, politics, but also some aspects of emotions as well. Like I said, the law has procedure. We are not saying he's innocent, we are not saying he's guilty. We are just saying follow the law and then let him prove his case. He hasn't refused to prove his case. So the people talking about forgiveness, what are we talking about really? The law is the law. The gentleman is ready to be tried. We have procedure that speaks to how it should be done. Let's have it done the right way, and we hear a decision at the end of the day.
Interesting one. And of course, even when he's convicted, it will throw the ball back to the chief executive on the political question and how it affects. Because I would understand that would be, sentenced to the ultimate sentence for treason. So it will throw the ball back. So I think it's a good one, interesting take. We hope to proceed with the trial and see, hopefully from the gallery, what turns up. Of course, for our dear viewers, the conversation is still going. We'll take a short break right now, and when we come back, we'll proceed with matters courts, matters politics in this very heated 2025. Stay with us.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media, or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and the proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
Thank you, our dear viewers. Welcome back to the inter-university debates, where, of course, we are having a heated discussion on matters, politics matters regarding, of course, the current move by the NRM caucus to reenact particulars within the UPDF Act that would enable certain processions of legal dispensation to continue in the military courts, of course, citing in military persons as a case where military courts can apply, indiscipline by military persons, civilians with illegal weapons, and the fact that, introducing an appellate possibility that cases convicted or handled in military courts ought to be or can be appealed in civilian courts. We had a very deep discussion on that in the first session, and of course, we are proceeding with the discussion. I would like to bring us to a matter a bit close to home. One, we had the sentencing, the most expedited sentencing of our fellow lawyer, Aaron Kiza, in the military court martial to 9 months for making noise in quote-unquote hooliganism, which of course we call contempt of court. And then we had recently our very own, let me say, your president, the most eloquent, capable Isaac Semakade, also sentenced in absentia, or should we say ex parte, ex parte, of course, for his famous case against the victim and the judge, Mr. of course, Justice Sekana, in this matter. What do you make of this, trend of of convictions and sentencing of lawyers for contempt of court in a politically heated period? Don't you think it has a dent on the legitimacy and trust of courts as a system of conflict management in the country, and of course protection of lawyers, which you all are? I'll start with you, Monica. Your take.
Thank you so much. Wow. What I can say is that we have had a very busy 2024, and 2025 is proving to even be busier.
In the legal world.
In the legal field, we are busy. We've been so busy. And busy doing, I don't know, not the craziest thing. Let me bring it to that. This is also a caution anyways. Busy as we have been, most of the lawyers have all taken a seat in the bus. Honest. We've had
the bus of the law society, or the bus of
the legal field, like
the political bus.
The political bus and all the legal field inside, right? Like all the key players. People have just sat and they're watching. Let me bring it up. This is the thing. We know. I feel like the country knows what exactly they're fighting for. They know what they're after. But at the end of the day, no one wants to get their hands dirty. We see and we know that this is not right. We see and we appreciate that it could have been better if they had done A, B, C, and D, but there's no one willing to do that.
But isn't that unfair for lawyers who, by landslide, elected and gave the mandate to a radical new bar to question issues of the day?
2024, towards the close of 2024, when we were very politically active, I'm telling you, we were the most active Twitter space. And if you tuned in and listened to the conversations there are very many important things were being tabled.
Yes.
That if we had addressed them at that point, some of these things that we're seeing now might not have taken place. The whatever it is that our friend is being our council is being, called out for or, done to or whatever, wouldn't have materialized. But the point is, I think that it made a lot of rounds in memes and all that, where very important questions and opportunities open up for us to have those discussions, and then they ask the general people who are listening in. People tuned in by the thousands, and guys are quiet because they are afraid to either put up their opinions, afraid to be scrutinized, or afraid to be, descending to what the general public is. And I mean, what the general public thinks, and at the end of the day, we are having what we're having. But the truth is, law is the law. We know the procedures. We know everything that is happening. And right now, since most of the people have decided to take a back seat, it's like we're all watching a game. And politically, it is going to blow up at some point. Because the politics is now also so deep into the legal system. It's no longer just the Besigye case. It's no longer just Aaron Kiza, the Kiza case. It's no longer just NRM Kakas or Semakade. It is deeper than that. And those that see it. But like I said, it is like it's like a boiling pot. It's definitely going to explode at some point. Yeah. So my position on the matter is, we see it, we know it, but the question is who's going to say it.
But I think in terms of, if you're looking at law, I wanted to get to that because law is a very big asset to the country. In fact, it manages conflicts for the state on so many levels.
It is supposed to, but the question
it does.
is,
No, it does. It does.
Okay.
The opposite of court is not no court. The opposite of court is war. Okay, so there's so much, including the Besigye case and all these things, that are useful to the state. So lawyers, as the midwives of that system, to start suddenly getting attacks. And in my opinion, it's actually what expedited the Supreme Court judgment. That lawyers, you make noise in court out of passion, and you're thrown for 9 months. And then you look at our president, in a case where he's the judge is the victim, he's also the judge, sentencing him. What do you make of that as a lawyer? Do you feel like we are more protected to stand politically? Or, what do you make?
Politically, well, and also in relation to the law. If someone who has a full and proper appreciation of the law is being treated the way they are being treated over certain things, then technically you would fairly say no one is really safe. Because if the president is calling out someone, and what they're saying is, you can't be the judge in your own matter. People have written books about this. There are precedents to this.
It's quite obvious.
It's very obvious. Even to a person who doesn't know the interior of court, knows that you cannot be a judge in a matter. It's biblical too. Find someone else who is neutral, present your case. But if people, all the authorities, that the decision makers decide to close an eye to this, and then make a decision in another angle, it kind of raises a lot of question marks for the rest to decide. Same story with, contempt of court is a serious matter, yes. But there are other fines that can be imposed on the individual as opposed to being arrested. We're looking at let them pay or something like that. Let them off with a warning. Like there are other things that you can do before you finally say enough is enough, arrest them. So running so fast to the most prominent or the most harsh.
And you mean 9 months and 2 years?
Exactly. It raises question marks. And it also, you wouldn't blame someone now to start thinking this may not actually be procedural or court. This may actually have a deeper something behind it.
All right. Thank you very much. Comrade John, your opinion as a lawyer to your comrades being, persecuted on grounds of contempt of court, 9 months, 2 years for discussing matters of, I could say, political but also public interest in Isaac's case. What do you make of this implication as an incentive or disincentive for lawyers?
Let me start with the one of Aaron Kiza, so that I actually have a comparison with it. with this one that recently happened. The one of Council Aaron Kiza happened when he was into the case of Besigye.
Yes.
And he was sentenced to 9 months. But the question still goes back to us and to everyone, what does the law say? The law on contempt of court is not very clear, but it is enshrined in Article 28, 12 of the Constitution, that except for contempt of court, no other law will be punishable without it being defined. So it is the only exception. The offense of contempt.
Is it also undefined in terms of sentencing?
No, it is. It is. For contempt of court, it is not defined for what really amounts to contempt of court.
Yes.
So the issue is, when it comes back to the UPDF and the issue of Aaron Kiza and the court martial, they relied on the UPDF Act actually when they were convicting him. So when you look at the UPDF Act, and at that time Section 171 and 2 around there, 71(9), that an advocate before a court martial and he undermines that body, he actually does what would amount to contempt of court, will be punishable for an offense, but the punishment will not be beyond 3 months. Now we're looking at Aaron Kiza suffering at the hands of people who don't know the law. They are sentencing him for 9 months. The question is, that is already an illegality in the law. The moment you go beyond your jurisdiction can be time, can be place, can also be sentencing powers. You don't have those powers to sentence someone to 9 months, yet the law says not exceeding 9 months. So already it was supposed to be an illegal conviction from the beginning, from the onset. Regardless of what he had done, the law would actually trash it in the dustbin of legalities, that it should not continue and it should not have any place in law. There should not be any effect, there should not be any implementation. But the Uganda we are having today is actually implementing an illegality and quoting the law to say that we're actually having it. We now come to Semakade's case, Council Semakade, senior counsel actually, Semakade. We understand he makes noise legally and he's always making noise on legalities, on matters of the law and everything. But the issue is, he made his comments on the various judges. I personally do not subscribe to them. I do not support what he did. If you're to read those comments, you actually might fear to post them on your status, to even post them or even retweet them. So I understand the comments he made were personal, were because he has interest in the issue. He's heading the new radical bar, but I don't subscribe to the abuses.
The issue of Sekana
yes.
is predates the radical new bar, because this is 2022.
And to the point that at the end of the day, we saw a case coming out on Valentine's. A happy Valentine's. As people are having romance, love, we saw Semakade throwing thorns instead of roses. So there were the counsel, I think he was resting in his restroom and he didn't anything happening until he received that case. Actually, he received it ex parte. He was, I think, not in court. So Justice Sekana Musa, he actually writes very beautiful judgments. If you read his judgments on commercial law, if you read his judgments on other matters, but I don't know what happened in this particular instance, that the law lord decided to sit in a case which is having an interest in the same case. Like, he has an interest in the same person. You see the law on, like, you should not be a judge in your own cause.
Yes.
The law does not mean you actually have an interest physically or directly, you have an interest. The law is saying that, do people looking at you in the same position think you have an interest in that case? You should now recuse yourself. Excuse yourself from the case and let someone else take it. We have very many judges who would have taken up that case and read it out or even make it. Why would he be the same individual interested in that what? In that same case? Yet he actually has the same issues with Council Semakade. Now the issue is, the law is called Nemo Judex in Causa Shua, that a judge cannot be a judge in his own cause. Like, you can't sit after you are being abused, then you sit on the same matter to judge the other person who has abused you. The issue is, fair hearing will not be seen. Even when you make any decision, we don't expect fair what? Fair hearing, because you also have an issue with the same person. So if the judge wanted to make that decision effective, very effective, to be one that would be groundbreaking, another lord would have taken it up. Another judge would have taken it up. There wouldn't be an issue. But the public is already seeing prima facie that there is no justice, even when whatever he quoted was right, even when he relied on the law. But the issue is, anyone who even didn't understand the law was saying, there is nothing right with that judgment. The person who is interested in the decision is actually the one making the decision and sentencing this person to 2 years. Were they 2 years?
Yes.
So we are now saying that all whatever is happening for contempt of court calls for a definition of what amounts to contempt of court. Because now the law laws that we are having and then people in authority are over misusing what amounts to contempt of court. Because I've looked at you, sadly, you will actually just say contempt of court because it's not defined. We shall see cases of judges who are like, you've dressed poorly, contempt of court.
And also the question of, does it have to be within the vicinity of the court? Because we have people online, you know, still dishing out. I mean, you could be a lawyer in the matter or somebody interested in the matter, and you go on social media and issue a statement. So the frameworks are not...
They're not very clear. But the issue is, it states, as it states, contempt of court. I do not expect a judge to come out and hook out individuals on social media that this is contempt of court. Otherwise, that judge would have failed his law school. Because we are now looking at the fact that contempt of court,
but
meaning the people
it can be wide. I mean, you can contempt.
There's an order of court that you are.
Yeah, there is that one of contempt of court for you not obeying the order, but the one that is before the judge that is trying to look at, that is the one that happens there and then. Now, for you to be, let me say, for me to go on social media and I abuse a judge, that would not be contempt of court.
Yes, and that is exactly why we need definition.
That's why we need, that's what I'm saying, the laws are
political,
overplaying with this definition of contempt of court. They'll just extend it to anyone. They'll even create avenues that even if you abuse my wife, that's contempt of court, is related to me. Me and my wife are one. We shall see all those cases coming up. So until we now go back to what amounts to contempt of court clearly being defined, we shall actually be suffering legally. We shall have people suffering legally. So we are going to see Council Semakade serving his sentence because I think yesterday they released the court order. Finally, it came out saying that, please, we need you somewhere behind the bars.
And he's out of the country. So we'll have to see again with the extradition. But what do you make just as a lawyer? This is just as a lawyer seeing your president. You know,
I do want to understand.
The president of Uganda Law Society. It's quite unprecedented.
Very unprecedented.
That the president of Uganda Law Society is behind bars.
Yeah, it's quite unprecedented that he's behind bars as a president, and it's also quite unprecedented that as a president he's also abusive. Like it has. It is not something that has been happening.
I mean that is a false equivalence.
No, there is this discussion and understanding that it is okay for you to criticize me.
Yes,
to an extent.
You have the right to be annoyed.
No. That's right.
You have the right to annoy you.
And I also have the right to give you what I want in pursuance of your annoyance.
No, I have the right to. I mean, it's a false equivalence to say that. It is, on the one hand, we have a president of law society, which has far-reaching implications. These are things law students are going to study in 2050, 2060.
True.
And he represents all of us.
Yes, and then you compare with his vulgarity, which is not a well-studied subject. There is actually proof that vulgarity, if you read Stella Nyanzi and a lot of the literature around that case, vulgarity, and also if you read Sylvia Tamale's book, you know, that in the arena of politics, the naked body of a woman is the deadliest weapon. And go to Monica's culture where women even point their breasts. So it's not a well-studied subject, but the fact that the president of Law Society, I think it's something.
I do want to appreciate that when he was coming, he promised changes. As a president, we actually supported him. I was happy for his win. Because he promised to change everything.
And he didn't pretend. You knew he was vulgar.
We knew he was vulgar.
So that is what they call a mandate.
And that is now why he's done suffering on behalf of whatever he's saying. But the point is, when he was coming, he had this hairstyle and we're like, okay, all of us are having bald heads, but yeah, we are going to front for someone who has hair, like plates. But at the end of the day, we are saying, okay, we can understand that. But your issue of you being abusive with those people, like, there is a way the Chief Justice explained it at that time when we were having the Judicial Service Commission conference. That there is what we call respectfully criticizing a decision or even criticizing an individual. You can come out and quote all the decisions of Justice Sekana as you quote them that here he was being impartial, here he was being partial, here he was being like this. It's okay. We actually understand it. But for you to go on and start attacking the individual as an individual, it goes back to judicial independence. It is actually written in the Constitution that by you attacking what that person has done as you go personal with that person, Article 128, the issue is that will be now beyond
But
what you
you
expected
see,
to do.
the argument there is the nature of public interest litigation is activist in nature, and you know it's the role is whatever tool of activism you use. Is the question, is it emancipatory to those involved, to the wider public? Does it have an emancipatory? It may abuse Sekana because Sekana
Has made a
has
decision.
made a decision that affects, you know, the citizenry.
But
So the question is,
the
is
decision
this
does not
tool of
change.
activism emancipatory?
It is not.
That's a very
The issue
important
is,
question.
at the end of the day, does it
Let's-
change the position of
let's
the law?
get-
It
let's
does
get
not.
let's get to you. Your take on before we move to another topic on having the president of Law Society now facing an arrest warrant, a conviction, and a sentence of 2 years.
Personally, I would say that of course it's unprecedented, but then we also have to separate the office from the individual. The office of the president of ULS it is an office that comes with a lot of privilege, a lot of respect, a lot of honor, because you're speaking for the entire community, the entire country, right? When we go out there and there is he's like the head boy of law school. I mean the head boy of the legal system, right? But now, when it comes to the individual himself, we have to appreciate that the gentleman, like he said, has a few setbacks here and there. We do not shy away from what we call positive criticism. We don't. Every system that needs to develop appreciates criticism, but the question is, what are you doing and how are you bringing it out? In law school, we have a quote that goes for, like, it's usually just to check us and how we are behaving. It is called conduct and becoming counsel, conduct and becoming advocate. I cannot stand here and start using abusive language against him. It will be seen as conduct and becoming. It means it is not expected of me in that space or in that time or under the umbrella with which I stand to speak to him.
What about vulgarity as a tool of activism
it can
in
never
public
be
interest?
A tool of activism.
Why not?
At the end of the day, this is Africa and we are African. There is morality.
I mean, I've just explained to you that in our culture, actually women point their breasts at you, and that is the strongest.
You are
that is the strongest.
So
No, you're talking about African culture. And some people, that's a very vulgar thing. Like, how can she, be naked? And similarly, Isaac, Stella Nyanzi, and the rest are playing an with whatever tools they pick,
Okay, the point is, have you emancipated the people you are trying to emancipate, or you've made the situation
But
worse?
have you even ever had anything from Stella Nyanzi as an impact from her? After her
I mean,
embracing
there's a quashed conviction that is a very strong precedent.
One out of how many?
Yes. So
see, the whole point is you are going all out. Personally, it's like these guys who go to strike and then they undress for people. Okay, yeah, the cause, we've received your message and everything, but the impact is on you. We're going to be seeing you every time we go on social media. You were there parading, you were naked. For us, we've forgotten the thing, we've moved, now you've become a meme. The whole point is, does your method yield more, or is it killing more than it's producing?
But net effect on the law society. Do you think Isaac's presence has been a net step forward?
When he came in, we had a lot of hope. We, the young lawyers, had a lot of hope.
Because of
But
someone
now
who comes out and speaks. When he comes out and speaks, you feel like they will listen.
This is another one of discretion. As they say, when the madness, the whole nation falls on one head, it is not enough to call one man mad. Anyway, before we sign out, recently we had the birthday of Chagulani, Sentam Robert at Kavule, Makerere, where his party, the National Unity Platform, decided to parade, their members, foot soldiers, quote unquote, in military format. I was just at Tarehe City the other day, and it looked quite similar. If you know the new military parade, it's small, so it's thick. Of course, that came with a lot of, opposing views online on social media, but also we saw attacks, not attacks, but searches at NUP headquarters and then also in Kamocha. What do you make of that whole political scenario? I'll start with you.
Let him start.
Okay. Please.
All right.
The lady has passed her birthright.
Well, I want to appreciate that we had a birthday. I didn't expect us to even, the country to even focus on a birthday, but they did. So we are looking at someone's birthday and the parade they had. The issue is there was a parade, people organized. I think they expected them to be disorganized. And then people dressed in the same attire that is red, and I think those are overalls that people wear even on petrol stations, mechanics. But then when they are together, I think that's when it became a threat for these people. Now, I want to speak not on the birthday, but on what happens after. We are now seeing the NUP offices being raided. And we saw them, they entered the premises, they broke doors, they removed whatever they removed, and then they went and released the press statement that actually we have covered ABCD, but you have not released the information about what you have covered, but you have covered something very important for this country. We said, okay, so it's all right. But then the NUP officer, the President Chagulanyi, also came out on the other hand and said, okay, we have also revealed some information from what these people have left behind. Perhaps we're even selling, we're peddling these things. We said that they moved small cameras, that small audio recorders, that these are things they left in our offices to track us, perhaps.
And fetishes.
Yeah. So we're now looking at the legal implication of whatever they did. Now we're looking at the police as a law enforcing body, being used as a political doll. And at the end of the day, it speaks to, they said we are going to use this information for purposes of what? Of trial. It goes back to, I don't know who is advising all of them as a group of the policemen and women, whoever is advising them must really be expelled. Because at that point, we are looking at what we call the doctrine of a poisonous tree. The doctrine of a poisonous tree is fully embedded within criminal procedure. That should you really ever want to create or even get information from someone, do it legally. Should you do it illegally, through, let me say, illegal searches. Number two, torture. That information will never be admitted in a court of law as evidence. However much it will be overwhelming.
So what is the legal format of a search?
The legal format of a search is laid down under section 60, 61 to 69, 70, 72 of the MCA, Magistrates Court Act. That should you do a search, first of all, you can search with a warrant, or you can search without a warrant. But in such circumstances, for example, they are guarded by the law, that one, have a warrant. If it is now searched with a warrant, you should now approach the individual. You actually approach the magistrate court of that area that actually want to search a particular what? Office, a particular person, a particular group of people, a particular room or house or whatever. Then you receive a warrant. Then you now take it to those individuals that now this is a search warrant for me to search your place. Those individuals are by the law required to respect that warrant. And they are required for them to respectfully offer you home for you to search whatever you want to search, but in their presence. Now, they even guide that you should not search someone at 1 a.m. Simply because you have a warrant.
In this case,
yes.
that is not
in this particular instance, they have no warrant. But the issue of now breaking in, why would it be hard for you to come and approach these individuals and tell them, I'm searching ABCD in their presence? Yeah. These people are always at office, but you came on Saturday and you want to say that you're operating legally. Come on Monday, when all of them are there. Working hours. And then you say you want to access their office. So that if they refuse, you now say that I was doing whatever I was doing in pursuance of the law. Because if you refuse an officer from searching you, you can actually, they are obliged by law to use force. That force was unnecessary under the law because they didn't have anything useful to get from there.
But I think you're underrating the political implications.
The political implications.
Because if you're looking at well, you called it a birthday and people in a similar uniform, but I think you're looking at it. I think you're looking at it in isolation. If you follow, if you've been following the processions of NUP, this group is actually has a name. It's called Foot Soldiers.
Foot Soldiers.
Yes, and the Foot Soldiers is around the idea that they have to protect themselves. Okay, it's itself. If you follow some of these dissenting groups, like Nation of Islam with their militia. So they have that. And if you look at the processions in town, you actually see elements of militant behavior by the foot soldiers. Now, picking from other lessons, these were the same groups that the Rutos mobilized in 2008 or prior to 2008, jokingly as well. We have these, and you saw what happened. They ended up in IC. And if you follow Mabirizi, he actually warned that Bobi Wine, you're very likely to end up in IC because of these. Should anything happen in 2026 elections, they will pick someone from government, and they will pick someone from. So I think you're underrating given that the conflict mark of Uganda is that we are not going to face a civil war. The most likely eventuality, if you follow Kavumba, is civil strife, and civil strife in urban centers, where there's the urban poor. So don't you think you're underrating the political?
I might not be underrating any politics that regards the procession. When you look at...
But do you agree that it has to be dismantled?
Well, let's now first understand how it is formed. When you look at whatever they were doing, they were hiding behind the issue of a birthday. But they were trying to salute their president, that thank you for whatever you've done for us and everything. But the issue is, the opposition, honestly, wanted exactly what those people did. The issue is, should you ever wake up and, let me say, look at the time when the police ignores whatever those people are doing. And it doesn't give them a hearing. It comes, let me say, it wants to search, it comes with a search warrant and says, you people, I want us to search your room. The magistrate of this area has allowed me to search. If they really had a cause of action, because I would not allow politics to really play like that, they want to overthrow the government. If that is true, or even if they had anything in mind, then they should have used the legal lines so that they avoid implications legally. Now the issue is, if opposition comes out and plays such tricks and such games, they want the government to play by them. And meaning, now who has won at the end of the day? The opposition has won. I want to look at a time when that is being done, and now the government comes up with a search warrant and says, I want to search your room. I have a thought that you people want to overthrow the government. It's okay. Then Chagulanyi refuses, and they use force. Everyone will blame Chagulanyi and his team. But now you're coming to cut and enter and seize anything.
I think that is discretional, because there's a big chunk of the public that was saying, we may not agree with government, but we don't also want. And you should remember that most Ugandans are urban middle class with a supermarket, a mobile money kiosk. They really have economic interests.
The issue is you want to expose him as someone who wants to overthrow the government.
It is not necessarily
not even overthrow, but wants to cause a strike or anything
urban
like that.
strife.
Yes. The best thing that they should have done would have had a search warrant, so that if these people refuse to be searched,
but you see,
now it goes back to them.
That is legalese. The substantive
now, by you playing politically like them,
the substantive is whether by force or less force, legal or slightly less legal, does that group have to, does the group stand at
the group stands? I honestly want to support the group stands. There is nothing wrong with that group. It's like us organizing all people who work at petrol stations to line up. That doesn't mean it's a political procession.
Okay, thank you. I'd like to hear from you. Your opinion on the same. Does the militia, or as Mabirizi called it, semi-militia, have a place in our political dispensation in a time where we are facing tumultuous politics, and also given our history as a country?
Nice that you point back to the history. I agree with him. That group stands. Reason being, Uganda is a multi-party system kind of thing. And no party is barred from starting another wing within their party.
A military wing?
It can be
not even military. Do they have any arms of government?
I mean, if it works like a duck,
no.
Quacks like a duck.
The law must be very clear.
As a duck, then you can't call it a duck.
If it works like a duck,
now imagine they were
like
all.
A duck.
Let me imagine. They put their Solomon Kampala, they put their Suvi, they put their Babi Chagulanyi, and they were all in a line with all the rest of the people, members of parliament.
But that is not what happened.
No. I'm imagining. Would
And
it
then
still be the same?
also, it is not in isolation.
Or is it because those people are not known?
The issue, it's not in isolation.
It
The
is
foot
not in
soldiers have been
isolation.
present.
Yes.
People feel their presence when Bobi Wine is moving around town.
True.
Yes? These guys, I don't want to air in because I'm the moderator, but you get what I'm saying. So, I mean, does your point really stand as to, this is just a normal political organization like NRM Youth League.
The problem is Ugandans are very suspicious. Like everyone wants to view the other person with suspicion. Okay, I'm trying to be neutral here.
Yes, yes.
Peradventure, we were looking at just a normal political party, NUP. In NUP, they have their organizational structures.
Yes.
In the organizational structures, they decided to call volunteers, or like churches call them our foot soldiers. Some churches will call them our street preachers. Does that mean you are supposed to view them with a lot? Okay, does that mean you're supposed to view them with suspicion even when they have done nothing that is suspicious? That is a question I'll pose. It is not for being answered. It's a rhetoric.
Yes, yes.
Now, when it comes to invading or breaking into their offices, like he has clearly elaborated, first of all, the group stands. There is nothing that stops it from not standing. Whether you are suspicious of them or not.
Even when they cause chaos in town.
The whole point is they stand. There is nothing legally barring them from not being legal.
Proceed.
Unless some hooliganism, what, but still. And now, breaking into their offices, that's, like I say, like he said, I'll borrow from that. It is it's procedurally wrong. You need a search warrant to do ABC and this. So, peradventure, it was actually a bait for government. They fell for it. Because now there is a way they kind of look to us. Like you just walk into someone's house and then turn it just because you are the police doesn't mean you tell me how to run my house or you break in and out the way you want. Like there's a difference between an office and a public toilet. You don't treat them the same way. So you need permission to access certain spaces. You've not asked me, I have not refused. You've not given me a chance to refuse either. So why don't you first approach, let me refuse, then you exercise those rights.
But there's also a big chunk of the population that was happy to see government take action, especially what you call no, both sides, on both sides of, I just, because it's, it's intellectual dishonesty to dismiss one whole side of the debate. There's a whole side of the debate, including people who normally in that constituency, or people who have reservations, especially the urban, the middle class elite, who have, reservations with government until it matters. Saying, I don't agree with the government, but I think this is beyond the line. Thinking about their boutique in 2026, their mobile money shop and all these things. There's also that side of the story saying, okay, fine, at least government should deter, or the state should deter sporadic spread. As you know, the principle is violence should be monopolized in a state. Both, yeah.
That's a dangerous.
Let me even give something.
No, but that's a principle of statehood, a pillar of statehood.
Just something. On the same, that we have, I don't know who has ever been to Chankwazi. Chankwazi usually hosts different youth from the country. They even put buses here, they take them for different trainings.
Yes.
I don't know what they're preparing there. I don't know which army they're making from there.
Chankwazi is a national leadership academy.
Do they, for them actually even have the Green Army, whatever?
Yes, it's a national, it is the state's.
Which law governs that whole parade?
The establishment, how did it come to be?
That you can be picked from Kampala here as a young man of 21, 22, you now go and start parading. And even you're given that what was happening was not even a parade.
No, this is not a political party thing. Even NUP can take its people to Chankwazi. NRM.
So when Chankwazi become a gazette of that,
yes,
Chankwazi has never become a gazette of people who want to parade.
No, but
that is why we have issues with it when it comes to politics. And when it's
the issue is about statehood, okay, and the likelihoods of conflict. That the state violence must be monopolized with the state, whether you love the state or not. There should only be one place with all the guns, the armory, and the military movements.
But that is impractical.
And the question of democracy, that is the difference between state regime and government. But as a matter of statehood, and that is why we have problems in Congo, that violence is in so many groups. So NALI is a state program. It is established by an act of parliament. Yeah, it was ratified and has its own budget. That NUP, government commissioners, headmasters, anyone has access for training. So that is the principle which I'm just instigating a debate. But,
You spoke about people who actually were happy when the government did this. I can actually say that, yeah, that was good. That was actually good. It shows that they actually see what is happening. But we have three groups of people. I don't know which one you're confirming yourself to, but we have three groups of
I'm
people.
a moderator.
We have those ones
Yes.
who have the very best knowledge about what is happening in the world.
Yes.
They actually have knowledge that actually Nope is actually not even instigating anything to overthrow the government. It's actually just tracking his president. There are those ones who actually know that it was doing it in good faith. We have those ones who are just there. They actually have no clue about what's happening. They have had on the news. They have added on the debates. They have also added on what people are speaking on different platforms, and they have made their own understanding that I think the NUP are doing good. I think the NUP are doing bad. Now we have the overwhelming majority who have nothing to do with all this. They have nothing. They know about what's happening now, and they are the ones who speak a lot when it comes to these things. They want to say that for me, the government, they actually take the side of the government is actually doing the best because they don't have a clue what the government is actually doing. Until like Gracie Bingira's case, he's the same person who supported laws that actually took him to prison. So he was among those people who knew nothing about the government he was dealing with. Those are the same people who actually are commenting on the tweets of the CDF and saying, oh my God, thank you for whatever you're doing. Until they are the same people to suffer on these same laws.
Thank you very much. Our time is fast spent. The discussion will continue in your hostel rooms, in your living rooms, in your saloon, in the bar. On some of these topics, one thing I'm glad is that we are able to weigh in heavily on both sides. My panelists were able to weigh in heavily and swindle like a pendulum bob on different issues. But at heart, really, I believe all of us wish and love and aspire for a Uganda that works for all of us, socially, economically, and politically. And so we urge you to share this discussion as far as possible and to make sure these discussions keep going. Thank you very much, my dear panelists, for that very interesting debate. I'm glad it turned out to be one, and I hope to see you again real soon. And for our dear viewers, till next time, I remain Okot Olaa, your host for today. Thank you.